That was 870 volume.
Okay, 870.
Volume 2. 870 is where they talk about the 874.
874.
Yes. 874 is for the it is their judgment. It is in the volume 2. Page, yeah. They have even highlighted.
874.
They are highlighted. It is only 874 which is not highlighted. So, my Lord, in making your judgments, you need to scrutinize some of these judgments, such that you may not be misled into making imperial judgments like this one. So, my Lord, let's start praying. We'll take one and regarding the law application.
Lord, really love it now. The record. But I'm going to highlight some of the judgments used by the petitioner and the purpose really is, my Lord, to highlight that there seems to be an attempt by the petitioner to mislead court. And my Lord, I will, before I launch into that, as the writer, my Lord, I need to highlight a very important concept of our practice. My Lord, that's the doctrine precedent. And why is it important? My Lord, the point we're making here is, why should you follow certain decisions and why should you not follow certain decisions? That's the point. My Lord, I will start with the decision of the Attorney General versus Uganda Law Society. Constitutional Appeal number 1, 2006. Constitutional Appeal number 1, 2006. And my Lord, in that particular judgment, I am interested in the excerpts on page 13 and 15, my Lord, 15 and I think 16. And my Lord, it is important that I read them because they will operate. They will operate as my backdrop against the arguments I'm going to make. My Lord, page 13, His Lordship Mulenga states, under the doctrine of certeidesis, which is a cardinal rule in our jurisprudence, a court of law is bound to adhere to its previous decisions, save in exceptional circumstances, in exceptional cases, where the previous decision is distinguishable or was overruled by a higher court on appeal or was arrived at by curiam without taking into account a law in force or a binding precedent. In the absence of any of the exceptional circumstances, the panel of the appellate court is bound by the previous decisions and other panels of the same court. So my Lord, the point is, if a court is sitting as a court of appeal, and there is a decision that was made 2, 3, 4 years back, that court has no option. Unless, my Lord, the rider is in that paragraph I have read, the case squarely falls within the circumstances under which they can distinguish, and that judgment which they are not following or they are choosing not to apply is, my Lord, by incuria. Now, my Lord, that takes me to what is by incuria. My Lord, it's also considered, if I read every page, you may not finish. It is also considered in the same judgment, and the part is highlighted, my Lord, by Justice Mulenga. By incuria, my Lord, operates in 2 instances. One is if a court sits and determines an issue before it in disregard of an applicable law, then that decision, my lord, becomes fine curiam, because it is made in the ignorance or in abscondment of an applicable law. That is one. Two, my lord, it operates when a court decides a matter before it, and in deciding that matter disregards a binding precedent, then, my lord, that decision becomes fine curiam, because it has been made in disregard of an applicable precedent. And then, my lord, that takes me to the third part of my argument, which is, why do we need precedents? Why do we need precedents, my lord? My lord, I will highlight it briefly because it's also covered in the decision of Attorney General versus the Criminal Justice Court. One, certainty that if a client walks into my chambers, I am able to advise on the basis of the law of the land. That is what certainty is. My lord, that also goes together with predictability. Predictability, my lord. I should be able to predict that the cause of action which I am bringing before a court to adjudge, I can predict the possible outcome of that cause of action on the basis of the decisions made by the courts. My lord, that takes me to the other one, which is stability of legal system. Stability of the legal system. My lord, the matter we are in, the proceedings we are in, I repeat, unique. Why, my lord? Because these go together with Article 1, which is the will of the people. And my lord, there must be certainty or stability in our legal system in determining what the will of the people is. My lord, that would bring me to the last one, which is integrity of the judicial process. My lord, what do they mean by integrity of the judicial process? That the process should be known to everyone, those actively in participation and those without or without the legal practice. Now, my lord, with that rider, the point I'm trying to make here is, it has been an argument we have started with all the preliminary objections we were facing. Is we have Supreme Court decisions, we have Court of Appeal decisions, but my lord, the jurisprudence in election petitions is unstable. Unstable, and that is the problem. My lord, I have an uphill task of going through this decision of retired Colonel Dr. Chiza Vestige versus YKM7 and another. It is a voluminous decision, but I have no clue. We shall have to go through it, my lord. And I hope, my lord, or really my prediction is that I've supplied a copy to the petitioner, that if they save some night tonight and read it, they will tomorrow withdraw the petition. My lord, that decision settles many of the issues we are facing. Yes. My lord, I am sorry, I'm trying, it is not numbered. I'm trying to sort it out, highlight the specific parts that I'm interested in, so that I can supply more minutes. But I will try to go through. My lord, this court, this decision has many principles that have been set, and I will go through a few of them and highlight the other principles. My lord, one of them is what we started with, is the issue of hearsay evidence. But my lord, perhaps before I launch into that, I also need to highlight to you, my lord, so that it doesn't get lost on the record. Part of the problem why I brought this voluminous decision is that we have a problem. For instance, the petitioner throughout this trial keeps on cherry picking from this decision, but not what it contains. Why? The decision is of 5 justices. 2 are in the minority and 3 are in the majority. And my lord, as the doctrine of precedent is, the decision that we go with are the decisions of the majority. But my lord, you have many Court of Appeal decisions picking the decision of just the Justice of Death, picking the decision of Justice Sekoko, perhaps because it is what is appealing to them, but that is not applicable law. My Lord, that's part of the problem that you have. That you have decisions of the Court of Appeal cherry picking from the decisions of both Justice Sekoko and Justice Oded, but that is not applicable. And my Lord, I will highlight. So my Lord, for purposes of this case, I'm interested in the decisions of the Chief Justice, as he then was, Justice Odoki. I will be highlighting the decision of Justice Karokora, and I will be highlighting the decision of Justice Ulenga, my Lord. My Lord, on the issue of hearsay evidence, it was settled. This is what court was faced with. Court was faced with affidavits that were made on the basis of one, belief, and hearsay evidence. And my Lord, the presupposition by the counsel then was that a petitioner or a party to election petition proceedings, my Lord, is permitted to rely on hearsay evidence. My Lord, how does it then become important? My Lord, their lordships, both the three of them, all of them, Justice Odoki, my Lord, on page 27 to 29, went at length to determine now, why don't we have to rely on hearsay evidence? And my Lord, I had highlighted it in my submissions on the field. One of the issues he said was one, election petitions are so generis. They are unique.
So if the petitioner
Yes,
first evidence of other persons, who then also swear that back and forth petitioner, how that context,
it's hearsay. The short,
so the part of the judgment which says that yes.
my Lord, maybe if I come there, I will perhaps, let me give you, my Lord, the context. Davids, I think, it's not numbered, but I have the numbers from the soft copy. Affidavits, based on information and belief, should be restricted to interlocutory matters. In pleadings which are finally determine the matter, only affidavits based on the deponent's knowledge should be acted upon. My Lord, in reaching this decision, they relied on two decisions, a constitutional court decision, Paul Kawanga Semokere and Zakaria Olum versus the Attorney General, and my Lord, Charles Mubiru versus the Attorney. And this was the reason, rationale, that in election petitions, unlike interlocutory matters, we are determining the merits of the case. And the proceedings are unique in the nature